Get ready for the dictation. 3, 2, 1, start. The true position in regard to the scope and nature of a petition of habeas corpus excludes the possibility of a challenge in regard to the constitutionality of an enactment. Stop. It is clear that the petitioners can challenge the validity of the impugned act in proceedings which have been initiated under the act against them. Stop para. I think it was only a dictum by way of obiter. Stop. The applicant complains against his arrest and not against conviction, comma, and the writ of habeas corpus is the only remedy available to him. Stop. He can undoubtedly challenge the unconstitutionality of the Special Powers Act during his argument at the end of his trial, but that must necessarily take, time. Stop. If the act is unconstitutional, he could not be arrested by the police without a warrant, and he must not be permitted to remain in jail even for one moment, and he has a right to be released instantaneously. Stop. Therefore, he cannot be told to await the result of his trial. Stop. Article 21 guarantees that he shall not be deprived of his personal liberty except according to procedure established by law. Stop. This guarantee is broken the moment he is arrested for doing an act that is made penal by a statute which is unconstitutional, and this court has, not only the power, but also the duty to issue a writ of habeas corpus to enforce his right to personal liberty. Stop. Para. The function of a writ of habeas corpus does not extend beyond an inquiry into the jurisdiction of the court by which the warrant of arrest was issued and the validity of the warrant upon its face. Stop. Jurisdiction is the power to hear and determine the subject matter in controversy between the parties to a suit. Stop. But proceedings under an unconstitutional act are absolutely void, and the act, being void, has no effect to confer jurisdiction. Stop. An unconstitutional law is no law, and an offense created by it is not a crime. Stop. If a court tries a person for an act which is made penal by a void act, it transcends its jurisdiction and he is entitled to a discharge just the same as if the non-jurisdiction of the court were apparent in any other manner, habeas corpus, volume first, paragraphs 30, 31, and 37. Stop. Mere error in judgment or proceedings constitute no ground for the issue of a writ of habeas corpus. Stop para. Return to the writ of habeas corpus, I have not come across any authority stating that a habeas corpus application cannot, on the ground of invalidity of an act, stop. It is, therefore, not correct to say that the scope and nature of a petition of habeas corpus excludes the possibility of a challenge in regard to the constitutionality of an act. Stop. In the end, I should mention that the learned Advocate General did not plead that this court had no jurisdiction to enter into the question of the constitutionality of the act in these proceedings. Stop. Thank you.